Discussing the latest in employment law, it's the Employment Huddle podcast with Guy Allen and Samantha Turetsky.
Morning, Samantha. How are you today?
I'm doing well. How are you, Guy?
Well, welcome everybody to the midsummer edition of the Employment Huddle podcast. I think it's just we had to do it. Issues have been coming up, and even though we've been doing these clips to keep everyone updated on a somewhat regular basis, sometimes some topics require some more thought,
Absolutely.
more dialogue. I thought we'd just listen. July 4th around the corner. Let's hop into some things that have come up. Let's talk about July 4th, summer parties. Anything bad can come from that? Good? Any recommendations here? For employers?
This is when I always feel like we take a good thing and turn it bad, right? It's like, oh, here's my lawyer again.
Don't shoot the messenger.
Right. It's not our fault.
Good.
Of course, anytime you're, as an employer, hosting some sort of event, you have to keep certain things in mind. You have to make sure everyone is still behaving properly. Definitely have to make sure that if there's alcohol being consumed at a work-sponsored event, that everyone's doing so safely and in a way that gets everyone home safe, especially, right, in the world of Ubers, Lyft, share rides, you name it. There should be no excuses for anyone leaving a workplace event intoxicated and driving home, right?
I mean, it's important with these. It's our recommendation, or mine anyway. Most of our employers have sexual harassment policies, anti-harassment policies. It's a really good idea to reconfirm and reiterate, and actually have them sign off on. Hey, by the way, we have our summer party. We like to do this for you, but we got to make sure you behave. Remember, we do have a very strict anti-harassment policy. Have them sign off on that just to kind of have a double layer of protection because summertime, music's partying, nice weather. Sometimes things get a little out of control, but hopefully everyone behaves and knows employers have a strong policy. It's all good, right? It's all good.
Yeah. You just, if you send that reminder, make sure everyone's on the same page. Make sure everyone realizes that the rules that apply in the office are the same that apply to the party, even outside the office.
So correct. It's important. A party is an office event, an employer event. So say if you're at the party and something happens, potentially, employer can be liable. But if say after the party, hours later they go to someone else's house and have another party, that is not an office event, and should not be anyway. Employers' responsibility. I mean, it could spill into the workplace. But that's just one little distinction. Another thing, given the summer vibes and the parties and the weekends coming up, is how often do we see people become conveniently sick on the day before and the day after the holiday or the long weekend?
Right.
How often do we see that? How often do we see that? And what do we do about it?
Right. Well, that's a tough one because in New York State with sick and safe leave, you really can't ask for proof of being sick until the third absence, right, under the law. So it is hard, but when you start to see a pattern in practice of an employee always taking off the Friday before a weekend, the Monday after a weekend, especially in the summertime, that's what we see a lot, right? And so it's hard of what you're able to do with it, except you have to start monitoring it. You have to start addressing it softly. And then if you start noticing that pattern in practice, then you can address it and say, we see what's going on. And then confront the employee about it.
Right. So, look, there are cases of fraud where employees are not being honest. It's very easy these days to get a medical note that says so-and-so's got a scratchy throat and has to be out for, Friday and Monday of the long weekend. So it's not hard to do that. But two things. First of all, if you really suspect there's an issue, social media is a wonderful place to find people. Everyone leaves a digital footprint someplace, and if you're having a party, and we've seen that, right, where employees have called in sick, and yet on Facebook they're having a wonderful pool party. So certainly that's one way of kind of looking into it without really looking into it hard. And the other thing, listen, if we really think there's fraud, I mean, you can send them to another doctor, and we see this often in FMLA situations or extended leave. The problem with that is you get into a battle of doctors. So if the employee's doctor says, yeah, it has to be out Friday and Monday, our doctor says, no, you're kidding me, got a little cough, then you got to send them to a third doctor to break the tie. So I always say, if you suspect fraud, go after it, but make sure you want to go after it because it's going to be an expense. It's going to be a process. So like you said, I think the smart thing is to just look at it tacitly, make sure it doesn't become a pattern, And if it certainly does, then you can be a little bit more aggressive with it. But as you say, it's a tight line in New York because 3 days you're not supposed to really ask for any sort of a medical note or confirmation. But I think if you suspect fraud, then I think that changes the game.
Mm-hmm. Yeah, I think the fraud aspect of it changes. But like you said, you just have to tread lightly, and you don't want to be in the accusatory position if you don't really know if that's what's going on, right? That's why you have to wait a little bit to get that pattern going.
Right. Correct. No, that's true. What do you do, or like have you seen where multiple employees put in for PTO the Friday before or the Thursday before July 4th this year and the Monday after, and you have half your workforce putting in for it, and there's no way you can accommodate that. What do you got to do with that? What do you do with that situation?
Right, so that's tough. We see that often because everyone always wants the same holidays off, right?
Yeah.
So there's two approaches that can be used that I would recommend. One is having your PTO policy based on seniority.
That's a good idea. Like that.
Right? Non-discriminatory. Whoever is the most senior person will get that approved first.
Yep.
First request, first approved, right? First in, first out. So if you put in the request first, it's approved first, it's your day. Non-discriminatory as well. I've also seen clients have specific policies set where the holidays are pre-planned. So if you want, let's say, Thanksgiving off, you're not allowed to then request Christmas off or whatever holiday, Hanukkah, anything like that. And vice versa. If you want Christmas off, you're not allowed to take Thanksgiving off. So it opens up the room for other people to get holidays around the same time of year. Maybe Memorial Day and Labor Day, 2 summer holidays.
Right.
And that's a policy I've seen, pre-planned, it's written, everyone knows how it goes.
I guess that's good. That's good. And the good thing about those policies is that no one can contest them. The policies are the policies. I think you better follow, not the bad thing, but the important thing is you better follow them.
Right.
Nothing's worse than having a policy and not following a policy. So as long as it's an equitable policy to apply things equitably, there shouldn't be an issue, but you have to be aware of either follow your policy, as you say, Samantha, they have one, or if not, make sure, it's equitable as to what you're doing, that, you're not allowing men to take off Christmas and not women, that type of thing. One other thing, I'm going to throw a wrench into this for you because that's what I do. What happens if someone says, okay, I got to take Christmas off because it's my religion. I got to do it. I need every Christmas off. And in fact, I need every New Year's off too, because that's my religion says I got to have New Year's too. What do you do about that?
Guy, you're always throwing a wrench into
Always.
That's tough because it not only becomes just a general PTO request, and now is a religious accommodation.
There you go. Now you get into that rabbit hole.
Yeah.
Religious accommodations, and you got to go through that same process that we do, regardless if it was it was a holiday or not, and ask about it and see if there are any other days that they can accommodate their religious needs, or if you have a serious question about whether the religion is being real, like somebody needs off New Year's, then you could try to get clergy involved, things like that. Again, you don't want to go down that rabbit hole. I mean, seriously, it does come up with the religion issue. I mean, all the time. I mean, I have to take Hanukkah off because I'm Jewish, and not because it's a long weekend or whatever the situation may be. So religion does kind of filter in to PTO sometimes, questions like that. So you got to be equitable, but then if there's a religious component, you got to be aware of it. It's handled like you would any other religious accommodation request. And how about this? Because we're just really going so smooth today. Religion leads me into the next topic I want to talk about, but it's a heavy one. It's a heavy one.
Where are we going?
So it's that whole political speech, religion in the workplace, and what can you do? What can employers do about it? And talk about topics that I think completely bleed into one another. Are the political and religious speech, and what's protected and what's not.
Yeah.
Maybe in the first instance, Sam, I mean, if you can talk about what is protected politically, forget about religion, between in the workplace and out of the workplace, and then we'll say, all right, but what if religion gets involved? So let's start as real simply as we can. What's politically wise. What do we got?
Yeah, so I think you're right. You have to take them separately at first and then figure out how they go together, because it is such a dense topic, and it's such a hot topic right now, given the climate that we've been in probably the last few years, right?
Yeah.
It's just become such a hot topic in the workplace. You really can't avoid it, it seems.
No.
It's interesting. Many people think political speech is a form of protected speech in the workplace. But in the first instance, right, how many times have you heard people say, it's my First Amendment right? It's my First Amendment right to say what I want to say. So that's a big misconception on what the First Amendment is, first of all. So that's the first layer to it. The First Amendment does not protect you in a private place of employment, and it actually only protects you against government action, your First Amendment right. Doesn't attach to your private speech in a private workplace. So there is no First Amendment argument to be made here. So let's just put a kibosh on that.
All right, out. No First Amendment.
No go. No
Okay.
go. It is no one's First Amendment right to say whatever they want in the workplace.
Okay.
So that's off the list. Under federal law and New York state law, there's no actual protection for political ideology, political speech, anything related to politics as a protected class.
In the workplace.
In the workplace, anywhere. So we talk about protected classes all of the time.
Right.
For example, race, religion, gender, sexual orientation, age. Those are protected classes.
Right.
Your political affiliation is not a protected class. So that's where you have to go second. So under federal anti-discrimination laws, there's absolutely no protection for you. There's no Title VII claim to be made because of your political beliefs.
So if someone would have fired me because I'm a Democrat or either way Republican, that's okay.
Yeah.
In the workplace.
There's that in and of itself, keeping it very basic, is not a protected reason.
Right.
Of course, like you said, political speech easily bleeds into other protected groups or classes like race, gender, age, right?
Religion.
That's religion.
Well,
That's different.
Is there a distinction between in the office and out of the office? Like what's protected? Like if I come in and, I'm wearing a MAGA hat and my employer doesn't like it and wants to fire me because of it, that could be one scenario. But what if I'm in a MAGA parade on Saturday? Can my employer do anything to me about that? Is there a distinction?
So there is a distinction. Before we go outside the workplace, let's stick inside the workplace.
Okay, fine.
We move on too fast.
Fine. It's so nice. I want to get outside already.
But in the workplace, your employer can set certain policies, or as employers, it's recommended to set certain policies to try to keep this under control. So whether that's dress codes saying there should be no political affiliation type of dress, right? Whether it's buttons, t-shirts, hats, like you just mentioned, and that should be applied even-handedly. But technically, because it's not a protected class, it doesn't have to be on its face applied even-handedly, but it is recommended that it is. So
I would think so.
Walk yourself
I would think so.
into hot water, right?
I don't think so.
So dress codes is one. Saying, look, no politics in the workplace, done. We're not doing it. Fair, even. That's a way to put it to rest, right?
Yeah.
It does become tricky because under the National Labor Relations Act, the NLRA, which we talk about often here, if an employee or group of employees is talking about politics as it relates to maybe the terms and conditions of their job, that becomes protected in the workplace. So that's the gray line. If people are talking at the water cooler about, let's say, tips on wages, because right now there's a lot of talk in the government about not taxing tips, right?
Right.
If they're talking about that may be, and it's related to the terms and conditions of their employment as an hourly tipped worker, that bleeds together. And so be careful on that of taking action too swiftly if it relates to the terms and conditions of their job. So even though you can say no politics in the workplace, we're not talking about that. This is a caveat. If they're talking about it to enhance the terms and conditions in the workplace of their employment. So that's just a nuance that everyone has to be careful of. So those are just some general tips in the workplace.
Let's throw another wrench, though. That's all. We're into the workplace and throwing another wrench.
All right.
And we talked about it. What do we do with, with religion? That seems to come up a fair amount. So for instance, what if someone is wearing their hair a certain way or, dreadlocks, like for instance, which, is it protected because of race? Is it protected because of religion, or is it a political thing? Or if they're wearing a certain garb or whatever they have to wear, is it political or is it religious? And I think that it definitely can toe the line there, with whether someone claims, hey, it's my national origin or my or my race, so that this is why I gotta wear what I gotta wear, and the employer could say, well, it doesn't relate to any of that, so we don't want you to wear it. And then they could say, well, but also my religion, my religion requires me to wear, whatever I have to wear. That's really tough. It's really, really hard.
That's different. That's when it all bleeds together, and that's a whole different story. If someone's saying I need to wear XYZ because of my religious belief, it's the same thing as the PTO. It's no longer just PTO, it's a religious accommodation question, right? So that's totally separate, and that's a different category. So unless you're talking a purely political item, right, that you do a double take, oh, is this really tied to your religion? Often it becomes a different category. It's not really about politics anymore. It's about, is it because of race? Is it because of gender? Is it because of religious beliefs? That's a whole different question. And yes, they bleed together, but once you're in that different realm of, oh, this hair in New York State is a protected race characteristic. So if someone's saying I'm wearing my hair a certain way because of my race, that is a protected group. And so that is a different conversation.
Right.
So even though they bleed together, it's still separate.
No, I totally get that. That makes total sense. Yeah, I could see how it does. It definitely gets tricky. I'll tell you where. Sometimes it's not our view by any means. If you have employers that have certain employees in the sales group that have to go out of the office and meet customers and clients, and they're dressed in a way that the employer doesn't really like, whether it's long hair or certain things that they have to wear, and it's religious based, then employers got to be really, really careful. There's not a lot they can do. If it was just for like a political thing, nothing to do with religion, then that's something you certainly can say, hey, you can't wear that hat, you can't wear that pin, you can't wear wrap yourself in whatever flag you want to wrap yourself in. If it's not, it has nothing to do with religion or race or national origin. The problem is, I do think they bleed together so easily.
Yes.
And people are smart. And there's a little thing out there called artificial intelligence, ChatGPT. It's not so hard. Not so hard right now for employees to say, my employer is picking on me and wants to terminate me because the length of my hair. What are my rights? And they're going to get 1,000 different examples, and if they file a complaint based on one of them, then you have a retaliation issue to worry about if you do anything. So that's protected. That's really really, 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 really tough. And just look, anything else, employers really, really got to be mindful of. But especially nowadays, people are just so sensitive, to obviously religious issues. So it's got to be careful, and political issues for that matter.
Right.
So have to be careful, I guess. And this is because times are difficult, and employers are having a tough time figuring out what the future is going to hold, and how many of them are just having a hard time sustaining their business and cash flow, that they find themselves in a situation they don't want to be in, which are layoffs or furloughs or things like that. And it reminds me a little bit of those COVID conversations that we had. Clearly not as bad, but where employers got to think this through. And like anything else, you can't do that on a whim. You have to take a step back and say, okay, who are we terminating? What are the demographics look like? To make sure there's no, even your policy might be neutral and there may be no malintent, but if it turns out that you happen to be terminating all women who are 64 years old and minority, and that's the way it turned out intentionally, you got a problem on your hands. So just make sure that before you engage in these layoff discussions or go down that road, really think it out with your employment lawyer and your business team, just to make sure it's being done equitably, even if it's unintentional. It could have these disparate impact consequences that can come from it.
Right. As you were giving that example, I was just thinking about if you have a position that's predominantly given to, let's say, one gender over another, and so when you lay off a whole group, let's say, and it's all men over a certain age, and all the younger people get to stay, maybe you have an age claim on your hands, even though your intention wasn't to be discriminatory. It was just that group has people who are over a certain age.
Right. And you get into that.
It works
where like companies want to save money. Very often The people with the biggest salaries are the older people. Money, salary is not a protected category. I mean, if
Right.
that's a reason to let someone go, you can, but you better show that. If that turns out that your layoff demographics show you're laying off predominantly, older people, then better be prepared to back that.
Right. That's a great example because that's such a
Thank you,
real
Samantha.
example of, if you're trying to save money, what do? Get the
Right.
largest salaries off payroll, right? Who are often the people who've been there the longest, which often equates to age.
Correct. So yeah, no, that's definitely a good example. And one other thing that just a little non sequitur, a little bit with like age and stuff. Very often, employees will say, "Oh, age discrimination," and they've only been there for a very short period of time, whether it's a year. Just employers should know that if the same person hires and fires that employee, it's almost a perfect defense to age discrimination because it's very hard for them employer to argue, well, within a span of a year, you turned into an age discriminator. It just doesn't make sense. As long as the same person is hiring and firing, just so our employers know that if employees start claiming that there's age issues and they've only been there a very short period of time, that's something that absolutely they should examine.
Right. Now, does that apply to any sort of protected group? Like if someone says I was fired because of my race, but it's the same person who hired and fired them.
You
Does it
would
work
think,
the same
right?
way?
You would think, yeah, and I think that's certainly something that you bring up, but it's just not as, I would say, concretized as the age, which is it's the same actor defense. It's just so clear in the case law that under age discrimination statutes and regulations that it's there. It's the same person hires and fires. It's almost a complete defense. I agree with you though. I agree with you though that if you could, that probably should be extended to almost anything, right?
Right.
In terms of, well, they hired me and I was a minority. I hired a minority a year ago, and now I'm letting the minority go. A year later, they all of a sudden turn into a discriminator based upon race or something. It doesn't make sense. So yeah, that's certainly something to take a look at. So
Interesting.
yeah. So is that it? Like in terms of like substantive stuff?
I don't think we dabbled in the out of work political speech. I don't know if you do want to dive into that.
Yeah, yes, because you stopped me, you interrupted me. You
Yes.
wanted to make a distinction between in work and out of work. Let's close that loop, and then maybe we'll go into a little more of it.
That sounds great. I just don't want to leave everyone hanging. They might say,
And I would have
maybe
been thinking
that's what
about
they
it.
were waiting for.
I would have been thinking about it all weekend. I need you to close the loop for me.
Perfect. So there is a huge distinction to answer your question between in-office political talk and out-of-office political actions. And specifically under New York state law, under the labor law, there is off-duty lawful conduct for political reasons is protected. So if you're doing something totally legal, right? That's the key there, lawful. If it's lawful off-duty conduct that in no way relates to your job, uses company resources, uses company money, is not on company time, and you're engaged in specifically identified political actions, which is listed in the statute, that can't be held against you at work. So just because your employer doesn't like what you're doing doesn't mean you could come back Monday and be fired for it.
So not funny, but interesting. Where say like I'm in a parade for a political party, and I'm going down the street in my parade and banging on the drums. And my employer looks at me with their binoculars. Oh my God! Look what guy's doing. He's in this parade.
Yeah.
He can't do anything to me if it's political or related. That's how they all have nothing to do with it. But if the parade makes a left, goes into my office building, up into my office, and the parade is just parading around my office, employer can do something about it because it's in the office. Is that what you're saying to me?
If you have a policy about no political actions in the workplace, but also at will employment, right? That's a little fuzzy because the argument would have to be made that by you stepping into the office building, it's now related to your employer.
Correct.
So yeah, if it's like a Wednesday and you're supposed to be at work, and you're on the clock, but instead you ran to the parade and ran back, that's different.
Or you just get the whole parade to come into the office, and the parade marches around the office. Then right, at that point it's in the office. So interesting, in the office, out of the office.
The law also has a safe harbor for employers, which gives a little bit of room. And it's basically if the action that the employee is taking off duty creates some sort of material conflict for the business, or has anything to do with like trade secrets, proprietary information, or business interests, the employer has more cover to take action. So let's say
That makes sense. That makes
right,
sense.
so like let's say you're filmed on local news at this parade and then clients see it and start calling, hey, I don't want so and so working on my account. This shows your business. Is this your, values? And let's say clients leave for that reason, and pull their accounts. Then you can likely take action because it's bleeding into the workplace.
Makes sense. Just real quick, wrap it up. A little work world talk. Summertime is here. Finally getting some warm temperatures.
Thank goodness.
Anything you got going on this summer you're looking forward to? Anything specific or just your usual fun stuff?
Just our usual fun stuff. The wedding's behind us.
Yes, it is.
It was great, but I'm so glad to just be able to relax, enjoy my weekends, not have to plan every second. So I'll just be spending a lot of time on our boat. We go to Fire Island a lot.
Very nice.
We've been checking out a lot of new restaurants on the water, which is really fun. So that's just been something that we've enjoyed doing. What about you? What do you have going on?
Well, first of all, you didn't let the audience know about the lobster roll crawl that we're doing.
I didn't want to steal your thunder.
The first annual Employment Huddle podcast lobster roll crawl. So, Sam and I are big lobster roll fans, and we figured, for the benefit of our listeners, that we would just take some notes. When we go to our lobster roll places, and at the end of the season, put together like a compilation of rankings of the best lobster rolls, on the island or New York tri-state area for that matter. So I'm looking forward to that. That is a sister exercise of the dumpling crawl I did in Chinatown last year. So we'll have two crawl lists for everybody, which is always good. Aside from that, so the weather's good. I'm gonna try to play some golf best I can.
Nice.
What a challenging sport. Darn, it really, really, really is. But I'm gonna try to do that. Play pickleball, of course. Try not to get hurt.
Please stay healthy.
Stay healthy. I gotta be here for you and for everybody. There's too much going on. So just try to stay healthy. How about that? Stay healthy. Have a good summer. Eat a lot of lobster rolls and exercise. To keep coming back at you guys for all this interesting stuff. And by the way, our podcast huddle hats are flying off the shelf. Flying. So if anybody
very nice.
Was that? Oh yeah.
So nice.
There's a few left, and we can sign them too if you like. So if you
special edition,
just write in. Yeah, happy to do that. So anyway, that's all I got. I think we covered a bit today, some interesting issues, but we're always here for anyone who wants to call and chat or write in, and keep an eye out for our little quick hits in between podcasts. So things come up, we can get to you right away. You don't have to wait for the full edition of the podcast. So
everyone should make sure to follow, subscribe to our social media channels so they can get those quick hit videos.
We are everywhere. So just keep your eyes out. We appreciate your support and your listening, and hope you guys have a great summer. We'll speak before the end, I promise. Cheers.